Hello, everyone. Thank you for joining us today for status and legal considerations for healthcare recruitment trends. I'm Rachel Carey. I'm a healthcare attorney here at Whiteford, and my practice area mainly consists of corporate, regulatory, administrative, and compliance issues with small and larger providers. And one of the areas that usually comes up is employment and healthcare recruiting. So we thought it'd be great to start the year to have sort of a status check of where we are with healthcare recruitment and give you some practical tips to consider when arranging these sort of employment matters. And to do that today, we have teamed up with the employment group's own Randi Hyatt. Randi, would you like to introduce yourself?
Sure. Hi, everybody. I'm Randi Hyatt. I am a partner in Whiteford's Labor and Employment Law section, and I have been practicing employment law for 30 years. And a lot of the clients that I work with are in the healthcare industry. So I'm very familiar with the issues that come up in healthcare and employment, and in particular, recruitment and retention. And so Rachel and I thought it would be great for both of us to sort of meld our experience and give some information on this very relevant and cutting edge topic.
Yes, and I appreciate her having her time here with me today. It's going to be very sort of question and answer, and again, very practical tips that hopefully you can use every day and sort of tell maybe when you need to seek more counsel to help with these sort of complex arrangements. But with that, let's go ahead and get into the first question, Randi.
Sure. So before we get into like the legal and the substance, let's, get some framework and just, speak in practicalities. What are you seeing right now in the market, and what are, either, issues, road bumps or obstacles that healthcare is facing with recruitment?
Sure. So the main one continues to be personnel shortages in really every category. And when you go into even more rural areas, they're struggling there as well. And because of those personnel shortages, they are having a high reliance on very expensive staffing agencies. So what we're trying to see is obviously making up for those shortages and maybe getting away from some of those very expensive recruitment contracts. And one of the ways they're trying to do this is sort of innovative packages that take into consideration, different frameworks in terms of, the number of days they're working, maybe sort of telehealth arrangements where possible, and just trying to really come up with new and innovative ways to make up for these shortages. We're seeing a little bit more retention, but again, retention's only great but when you're already fully staffed
and able to recruit.
Correct.
Right. Okay. And now with respect to physician recruitment, what might be, what have you seen, and, is it morphing at all? Like what do you expect what has happened, and what do you think will continue to happen in 2024?
Right. So after COVID and even during COVID, you pretty much saw a lot of physicians who were closer to retirement ultimately take it a little bit early, or maybe just change their plans and just say, hey, even in, with 10 to 15 years left, maybe just saying they want to consider doing something else or being in medicine in a way that maybe isn't as much direct patient care. And with that, it's put a high reliance on, the new graduates, and the new graduates are having a different attitude towards work and what they want to do with their workload. They don't want to necessarily work a full week all the time, and they don't want to take on the same caseload that maybe prior generations did. We see a lot of more specialties or specialists coming into the market, and with that, that only makes it so you need even more people to cover all the gaps in your patient load. And to do that, again, they're looking at different ways to bring people in, either part-time or in, using telehealth again, but just trying to come up with different ways to address sort of the new norm.
Sure. So I imagine that brings up a lot of, structural and legal challenges and considerations. What have you seen in that regard?
So telehealth is always something that that is constantly sort of having updates because there were certain waivers that were put in place that keep getting extended but not being permanent, a lot of them. So that keeps continuing to come up, and we'll address that a little bit later. But whenever you have an employment arrangement, we do a full review of any sort of contract that comes in terms of, reps, warranties, general services, and things like that, payment considerations. But we generally look for these sort of five things here: the anti-kickback statute, paying for referrals, patient inducement and steering, self-referral or start considerations, and any sort of arrangements that might violate that. We also, we try to warn our clients about any false claims liability, and then HIPAA as well, that any violations there, whether intended or not, and how minor can shut down a practice if, the violation is that large. You don't necessarily always see all these referenced in a contract. I will see regularly HIPAA citations. But when you're examining for these other matters, you look at sort of the services that are being contracted for, the fee arrangements, and the location as well, to sort of incorporate these legal considerations into whatever arrangement you're doing.
I know one thing that I see with clients that I work with, especially doctors or other, APPs or healthcare providers, is trying to, as part of that, like the recruitment, doing sign-on bonuses, and then asking or requiring really in the contract that the healthcare provider remain employed for a certain period of time. And as more time passes, the repayment obligation of that sign-on bonus will sort of abate with time, so that if they stay for, let's say, 3 years, there's no repayment obligation, or even a year, but then anything lesser, there will be a repayment. Is that something that is unique to this area, or part of the legal consideration that you look for in the contracts?
It's definitely a part of the legal considerations that we look for in the contract, because when you're trying to comply with Stark and any kickback, the main thing you have to consider is commercial reasonableness of the overall arrangement, and fair market value. And if you're giving someone an excessive bonus with no real parameters, it doesn't look like fair market value. And that's one of the main things you have to consider when you're setting up these contracts, is the supporting documentation that demonstrates fair market value, and writing into the contract that, we're only going to give you this bonus if you commit to this amount of time. And, here on our next slide, in terms of common issues, that's the main one: excessive compensation and no supporting documentation at all. I recently saw, in December 19th, I think OAG or Department of Justice announced a false claims liability for Stark violations, where excessive bonuses were given to cardiologists. That is just no real reason. So, and I think that settlement came down to $345 million. So, you want to make sure that you are supporting these arrangements, because the penalties can be extremely large.
Sure. Could that be, that actually, sorry to interrupt, but that has me thinking, like, if a hospital is having a hard time recruiting, we'll go with that example, for cardiologists, or it's in an area where it's, like more rural and a little more challenging to get quality of care than you could in like a city like Philadelphia, where, everywhere you look, you've got these fantastic, hospitals. Like,
yeah,
is that considered when the evaluation is made? If there is,
it's definitely considered. Yeah. Usually when we're getting these fair market value evaluations, they're done by independent consultants. And so those things are all taken into consideration. And one of these things that we stress is that any of those assumptions and difficulties are put into the evaluation that, in order to entice someone to come here, this has to, be considered, and the amount that you're offering probably will be adjusted to entice someone to come here. But again, you have to document that and document it in the independent evaluation. I don't usually get as much pushback on getting these evaluations from bigger health entities, but if we're going with a smaller practice or some sort of startup healthcare company, they don't usually want to do it. But for the most part, I would say a lot of our usual health systems understand the value of getting those sorts of fair market value independent evaluations.
Sure.
The other thing is just evaluating the whole agreement. Anti-kickback and Stark, they have exceptions. So Stark has exceptions for employment arrangements, and then anti-kickback has safe harbors for personal services and management agreements. And fair market value is a big one that people get themselves in trouble for, but there's other parts of those exceptions and safe harbors that have to be met. One of the things I mentioned was commercial reasonableness, and that's one that people need to always consider as well. Sorry, my light is, I can't figure that out, but you have to meet all aspects of these, and if you fall outside of them, you no longer have that protection to say that you're compliant and not exposed to liabilities under those laws. Proper record keeping. Again, I think sometimes when we talk about these arrangements, it's easy to be like, well, why didn't you keep proper documentation for this one contract? But when you're in-house counsel for a busy health, very busy, large health system, you're doing contracts and position arrangements and other sort of contracts all the time. And you're relying on your paralegals and people under you to sort of do this proper documentation and at least do the initial intake. So, training your staff to know, just sort of very bare bone things they need to look for. If they come in with a fair market evaluation that is above a certain percentage, flag it for you to look at, and then just also make sure that you have a proper filing system so you can pull these at any time.
Are there other things that can be done to sort of help avoid these mistakes and pitfalls that you've seen?
Correct. Yeah, there's a number of things. Again, the independent evaluations are always great, but you can also look to other sort of well-accepted market surveys on position compensation. Now they are kind of done in a snapshot in time, so they're a little bit behind, and all of our clients usually want to be, they're working ahead. So
Right.
they always have to keep that in mind, but it's always something that they can do to help support the compensation package that they're getting. The other thing, again, as I mentioned, is, just because of a fair market evaluation comes in at 50%, you should still examine that for the overall compliance with either the personal service safe harbor with anti-kickback and with the exception for employment under Stark. So anti-kickback, to be compliant there, needs to be at least a year, has to be identifiable services, and again, commercially reasonable. And the compensation methodology has to be set in advance. It doesn't necessarily have to be a set number in advance, but the methodology has to be set in advance. And if it's based on outcomes, you need to have a little bit more documentation in the contract and the supporting documentation showing that it's going to be based on outcomes that are clinically supported. You have regular check-ins. If the benchmarks are not met for those sorts of arrangements, that there'll actually be certain repercussions for that. And again, just documenting that is like the best way in the agreement and sort of your overall records.
If I can ask a quick question on that,
yeah.
The outcomes are, because of the challenges with recruitment, are healthcare providers looking to want outcomes to be part of the compensation calculation, or are they looking to not have that be part of the calculus? I don't know if there's a trend there that you've seen.
The health systems more so leads towards outcomes, because that is where their compensation from Medicare and Medicaid is going to sort of value-based care. The physicians not as much. They kind of want a, standard guarantee. That's always kind of what there are. And you can understand that from both sides. But if they see enough upside on their end and the physician feels confident that they can meet those, they'll take that. And that's sort of where we're going. And that's why they would get into those arrangements. But the trends is always, continues to be towards value-based care.
Sure.
For the Stark exceptions, again, it's a little bit more just arrangements cannot be direct or indirectly considered for referrals, and the fair market value and commercial reasonableness. And with commercial reasonableness in the last couple of years, they've clarified that it doesn't necessarily have to be a winning arrangement or one where there's a profit made, but there has to be a legitimate business purpose, is how they defined it. So I mean, yeah, if you're in a rural area, but you actually have an essential service you have to offer to keep your license, I mean, you might not be making money, but in the situation to stay open, to keep the hospital open, you have to offer way more to get a physician in there. That could be a commercial reasonably supported situation there. And then again, the takeaway there is just make sure that you're always documenting.
Sure. Yeah. So I know one of the things we've talked about, or you've hit on a couple times, is, the gaps and needing to fill the gaps because, physicians are retiring or they're going specialized. And obviously COVID made telehealth very much, the rule versus the exception. And that seems to be continuing. So what are you seeing from your angle with compliance concerns with, this virtual sort of medical care?
Yeah, so a big one is making sure you get paid for telehealth. Prior to COVID, there was a lot of restrictions on what you could offer and get paid for. So, and right now, everywhere's penny pinching to make sure that they get everything in so they can stay open. In terms of practitioners that are going to be using telehealth, there's been some extensions given again to the services that can be offered via telehealth through the Consolidated Appropriations Act in 2023. It's been extended for another year, definitely through 2024, and it allows those practitioners to report their location as the general provider location. But there is some issues still if you're going to be a new provider, if you're just enrolling for Medicare for the first time, giving your location, because the MACs require a provider service location when you first sign up, so that you still have to use your home address. And I've had a lot of questions about that, people not wanting to give out that information, but there's not really much we can do. I haven't come up with a good answer to that, and some of the articles I've read basically say the same thing. It's just kind of where they're at. If you want to get paid through Medicare and the MACs, you have to give that where you're actually giving the service. The licensure regulations, usually in most states, you need to have a license where the patient is sitting in which state. There's an interesting case in New Jersey. They're bringing a dormant commerce clause and privileges and immunity case, basically saying that their patients in the state are being discriminated against, not able to get a specialty level of care from very specialized providers out of state, which I can see happening. And a lot of those specialty providers out of state aren't going to have a license in each state. So it'll be interesting to see where that goes, just because I don't really see anything too specific with what New Jersey is requiring, at least on that level, that most other states don't also require.
That is interesting. Leave it to a lawyer to make telehealth a constitutional issue.
Right, I know. I'm very interested to see how that goes. But with that too, just looking in, physician, nursing, anything, look at the Board of Medicine, or the board regulations for telehealth, because they'll have specific requirements that aren't in one. I'm usually dealing with a lot of people who are setting up a practice and want to work in like 1 or 2 or 3 states and don't look at those, and there'll be like some specific requirements. And then with that too, especially with sort of advanced practitioners and, nurses, advanced practitioner nurses, and physician's assistants, looking at the scope of practice. So it might be, Maryland or something, but it could be a little more limited somewhere else. Another thing to consider is the DEA's Ryan Hyatt Act has been waived, still being waived continually for right now, but that act requires one in-person evaluation before prescribing controlled substances. So that if that eventually that waiver goes away, it certainly will change how some people are doing their telehealth medicine business. If you have to have an in-person evaluation or an initial one or one at some time, and your provider's 2 states away, it's definitely something that it's just an interesting thing. We'll have to see where that goes.
Is that something where like the healthcare provider, the telehealthcare provider could delegate to a provider who is in the state where the patient is?
There's ways around it. You can do it where you have an in-state provider with a license is like in the room or at a specific location. The patient goes to that location and that has a license somehow. But it's just one of those things that if you're all telehealth based, you would have to probably make a business relationship and pay, obviously, whoever that is, to make sure that that is acquired and provided for your business. And it's just not something a lot of people want to do, but we'll see where it goes.
Absolutely. Okay.
And on your end, on the more sort of general employment end, what are you seeing happening here?
Yeah, so telehealth, obviously, it seems like it's here to stay. And then from an employment lens and perspective, it's certainly bringing up unique issues. So telehealth is obviously what we're talking about, but just in the context of what telehealth is, it's, remote employment. And so when you have somebody who is a healthcare provider doing that telehealth, things to consider. Well, where are they residing and what employment laws, state employment laws would apply to their, employment status, assuming that they are an employee, which is another issue. Are they an independent contractor? Are they an employee? How are you going to recruit and onboard and transition and train and handle all the things that you need to handle when you bring any new employee on, but you're doing it in this telehealth virtual relationship. So there's, the traditional issues of having a remote employee that you need to navigate and consider. And then there's the added layer of this remote employee being a healthcare provider and the additional obligations and nuances that, nature of the relationship brings, and the other related issues of like, payroll taxes and unemployment and sort of making all the decisions and, having this virtual model, how you handle that, how you sort of contain that. If you're going to have restrictive covenants, what is that going to look like? Because with telehealth, the ability to practice in more than one location is obviously much easier. And it's the whole point of telehealth, especially with the waivers. Yeah. So, those are interesting, still unfolding, and people don't want those restrictive covenants, the healthcare providers, because as we've been talking about, it's hard to keep, it's hard to, get people. And so if they're going to say, well, no, I don't want to be sort of prevented from going elsewhere if this relationship doesn't work out or when it ends, then, a lot of employers are losing the ability to have those restrictive covenants that once upon a time they could. And so you're, having to recognize that you're not necessarily going to be able to stop a doctor or a healthcare provider from, setting up or going to work for a competing hospital or health system or medical practice, because it's just too hard to get doctors to come in the first place. And so, there's a give there that needs to go away. And then, of course, there's, the litigation issues of, the misclassification, employee versus independent contractor. Are we doing expenses correctly? Are they getting paid correctly? Are we tracking time with telehealth? Typically our healthcare providers are going to be exempt, but not all are, and some may want to be paid hourly, which you can do. It's not illegal to pay somebody who is exempt on an hourly basis, but then that means you've got to track time and, is there overtime? So there definitely are a lot of unique issues that come up and that, we need to, try to figure out pretty quickly. And so I imagine as telehealth, I think from my perspective, it seems to be expanding, at least what I've seen. I think the issues are going to continue to expand as well.
Yeah, and they tend to kind of always sort of be like, well, we're doing it, and then they're already doing it and they want to backtrack. So there's one thing that we'll tell you is we certainly help you if you've already started in some telehealth capacity and maybe haven't thought through these issues, but we would love to help you on the front end too to make sure everything's okay beforehand.
Right. Preventative is definitely the better position than reactive.
Yeah.
I think we always serve our clients well when we can partner ahead of time, but there are times when things happen and you're not necessarily expecting it's going to be an issue, and then it becomes one. And well, we deal with that all the time as well. So
yeah, no, we take it all here. And again, we are hoping these tips were very practical use. Again, small or large entities, it's a lot to track and a lot to handle. Hopefully some of it will give you means to sort of get through some day-to-day stuff, but for the more intricate and really sort of nuanced arrangements, we hope that we can be of assistance. Myself or Randy with anything, please reach out. And we hope that you got something out of this webinar today. We hope to hear from you soon. So thank you for joining us today.
thank you all.